Okay, everyone, we're heading back from, I'm sorry for the background noise, the status conference hearing at the Denver court. So it was a bit of a mixed bag. I'm sure you'll hear a lot of chest pounding from the other side, but it was a draw. It was a draw with a slight advantage to my side. And the advantage to my side is that there is now an evidentiary hearing set for the 21st at 1:30. For those of you who don't know, an evidentiary hearing is like a mini trial, but without a jury. So it's like a mini bench trial. You get to present evidence, you get to call witnesses, you get to question witnesses, though the judge does most of the questioning. I'm not gonna lie, I'm nervous. I've never questioned witnesses before. I'm not an attorney, but I held my own today. But what you're gonna hear a lot of chest pounding about is that I kind of messed up in the beginning. So I was talking about the case about Dave Williams, the GOP chair, versus Palazzi, I think that's her last name. They had a TRO, which is a temporary restraining order, granted. Well, it got reversed last night, and I didn't know that. So I had represented to the court that there was a TRO, and that wasn't accurate. But once I explained to the court, listen, I'm pro se, I'm sorry, I didn't know it got reversed. I don't get to view live updates. In Colorado, it's not like other states. If you're pro se, you have to actually email to ask for latest filings, and there could be a couple days delay. So the court was understanding with that. Plus, I don't think I did a good job of responding why the TRO was reversed. The TRO was reversed not because it wasn't valid to issue one. It was reversed because there was some facts that weren't accurate on attempts to serve the other side. This was a TRO that was granted ex parte, meaning the other side wasn't there to argue their case. Nothing in this case is ex parte. I don't like ex parte. I believe in that proverb that says one man seems right till another argues his case. So I got a scolding from the judge then. That was deserved. But it went up from there, because when he was looking through the filings, he said, okay, I get that you're pro se. I'm going to cut you some slack. He goes, by the way, these are really good filings for a pro se plaintiff. So that felt good. But basically, he said, I get what's going on. Where I think he lost his way a little bit was in concentrating on the political aspect, where this is more a contract law and corporate law aspect. The LPCO voluntarily chose to be a nonprofit corporation. They didn't have to. They did that in order to get corporate immunity. Well, with that comes responsibilities. So it isn't merely a political question, it's also a corporate law question. So we're going to have to deal with that some more, but having the evidentiary hearing is really going to help, because we'll be able to get into bylaws and things like that. So I am very confident there. We are lining up our witnesses. I will probably be asking for funds to get a professional parliamentary opinion. While I can certainly give one, and I have the exact same credentials as the one on the other side, I'm a party. That doesn't look good. So it's good to get an independent opinion. So I'll let you guys know how much that might cost. What else interesting happened at that hearing? We talked about my request for corporate records. In the spirit of amity, I narrowed down my request. Plus, the judges like to see that you're working together. I did not eliminate the rest of my request, but I said it may become mooted depending upon what the board does on the August 12th vacancy committee. So it was kind of a carrot to them that I won't be seeking all of this caucus stuff, all of this RFK stuff, if they don't try to put RFK on the ballot. So what I told them, though, was non-negotiable was the membership list and correspondences inside the party. So we're going to be talking about that. their attorney's nice. I've known their attorney for a bit. So we're going to try to work out things as much as possible. That's what judges like. Now, an evidentiary hearing, as I said, is like a mini trial. So it is appropriate for you to attend that. DM me, I'll give you information. Just do not be disruptive or you will get escorted out of the courtroom. But a public is certainly allowed to attend. So if you hear the other side going, oh, there was some kind of win. No, there wasn't. There really wasn't a win on any side. The judge basically said, well, Secretary of State's on your side, meaning me. I'm not really going to get involved until something actually happens. And what he defined as something happening was two things. One, the Secretary of State changing their mind. And two, them trying to put different candidates on at the August meeting. If they are smart, and now I'm going to get a little saucy, if they were smart, but now we are really talking counterfactuals because they're not, but if they were smart, they would just go back to their prior position that they're not putting anyone on the ballot, and then it would default to the Secretary of State's position. So if anyone wants to show this to Hannah, if she wants to decide to become smart all of a sudden and stop listening to dumbass Jim Wiley, that's what they'll do. All right, bye-bye.